Now let's move to contemporary America. More specifically, the role the United States Supreme Court has played. By defining a constitutional right to privacy, by affirming equal rights, and upholding the rule of law. Membership of the United States Supreme Court has changed over time. Where Thurgood Marshall was the first African American to sit on the bench, we have seen an expansion as the membership of the U.S. Supreme Court has included women and minorities, such as Sandra Day O'Connor, Ruth Bader Ginsburg, and Clarence Thomas. The decisions of the U.S. Supreme Court have expanded individual rights in the years since Brown versus Board of Education, 1954. And our question, how have these decisions of the U.S. Supreme Court promoted equality and extended civil liberties? The civil rights movement of the 1940s, 50s, and 60s provided a model that other groups have used to extend civil rights and equal justice. Not just protest, but also challenging laws in the courts. The U.S. Supreme Court protects individual rights that are enumerated in the Constitution of the United States. Most of these interpretations have come from the 9th Amendment to the Constitution. These have protected individual rights that, again, are enumerated, that is, extended in the Constitution. Whereas they may not necessarily be listed, they are certainly implied for all Americans. The U.S. Supreme Court has identified the constitutional basis for this thing that we call the right to privacy, that any American is protected in any areas where he or she should be free from unwanted government interference. You might find that nowhere in the Constitution does it guarantee our right to privacy, but every American has come to expect it, and the Supreme Court is left to defend that privacy. When we take a look at the United States Supreme Court, it has the ability to invalidate legislative acts and executive actions, and that the justices agree would exceed the authority granted by the government officials in the Constitution. This is judicial review, as you recall, and going all the way back to John Marshall in 1803 in Marbury versus Madison. It is an important part of checks and balances that work so that the court can be the keepers of the Constitution.